Good afternoon, everyone. My also help to bridge the gap between practice and theory. And they remind us that
of sexual violence cases and victim support in Korea. She serves as the director of WULI, the Feminist Research Institute affiliated with the Korea Sexual Violence Relief Center, and the director of the Korean Institute for Gender-Based Violence. She is currently a research fellow at the Seoul Foundation of Women and Family, where she conducts research on gender-based violence and women's policy in the city of Seoul. Her doctoral dissertation focuses on the marginalization of sexual violence cases and the legal abuse committed by perpetrators. This important research was later developed into a book which has been published in both South Korea and Japan. Today she will be presenting under the title "Ask each presenter to respond to the discussion question about 8 minutes, no more than 2 minutes." And regarding the discussion question for Dr. Kim and Dr. Lee, due to time constraint here, Ms. Mi-kyung Lee will read the discussion segment on behalf of our two speakers. Please, go ahead, Mi-kyung.
Hi, I'm Kim, or Mi-kyung. I am a current high school student at Deerfield Academy in Deerfield, Massachusetts, and I will be translating for speakers Mi-kyung Lee and Bo-Hwa Kim. So first of all, for the responses that Professor Mi-kyung Lee has responded to, the first question was, the monitoring project has been going on for 20 years. What would you say have been the main changes? Among the various issues that you mentioned, which aspect has improved the most over the past 20 years, and which issue has become more serious? This was a question proposed by Kiara, Pasari, and Ho-Jung Kim. One of the most significant changes has been the establishment of legal and institutional measures to prevent secondary victimization, along with a growing awareness among survivors about their rights. While the awareness of those in charge of the criminal justice process has also improved, I believe there is still much room for progress. A major concern today is the attempt to block survivors from reporting the weaponizing the legal system through the marketization of legal services and retaliatory counter-accusations. However, what is truly noteworthy is that survivors have not been silenced or defeated by these tactics. In order to increase the number of stepping stone cases, I believe it is essential to enhance the gender sensitivity of professionals involved in the process. This requires diverse and ongoing forms of education and training. The second question that Kanoko Kamata has proposed was, in page 4 you mentioned that notable progress has been made, such as court acknowledged absence of resistance does not imply consent and focus on presence of consent, and so on. Why do you think this happened? Is it caused by feminist movements, societal value changes on gender, or anything else? These changes have undoubtedly been shaped by the consistent demands of the anti-sexual violence movement over the past 35 years, especially the achievements in enacting related laws. However, I believe the more decisive factor has been the voices of survivors, their courage to speak out, and their growing awareness of their rights. Today, women no longer stay silent or endure in the way they once did. The third question that Kiara Pasari proposed was, are the results of the monitoring program shared with judges, prosecutors, police, etc.? If so, what have been their responses? First of all, the results are reported in the news every year, and KASBRC sends official documents to the Supreme Court, the Supreme Prosecutor's Office, and the National Police Agency. However, not all members of these institutions are fully aware of the monitoring project. In this regard, I believe continuous effort and strategic engagement from civil society organizations are still needed. Some judges respond differently. One judge even used a personal connection to complain to KASBRC, while others simply ignore it. On the other hand, there was also a judge who attended the award ceremony in person and said in her acceptance speech, "I am following your monitoring work. You are educating us judges. Thank you." administrator who placed the award plaque at the center of her office, saying it was the most meaningful award she had ever received. Police officers, especially those who received the Stepping Stone Award, often attend the ceremony. It was heartwarming to see their family members and colleagues join them to celebrate. Many of them say things like, I was just doing what I should, but thank you for recognizing it. I will keep working hard. These moments gave us activists a lot of strength and encouragement in judicial decision-making, or the court ruling in the criminal trial of Mi-kyung sexual violence case, which was also mentioned in the presentation. In January 2005, during the very first year of the Citizen Monitoring Awards, Judge Park Chung received the Stepping Stone Award. He ruled in a case where a woman, after fleeing domestic violence and taking refuge in a relative's home, was sexually assaulted. In his judgment, he stated, "It is unreasonable to demand life-threatening resistance in order to prove sexual violence, breaking away from the narrow interpretation standard and deliver a guilty verdict." Since then, particularly during the #Me Too movement in 2018, a number of significant rulings have followed. One landmark decision came from the Supreme Court in a case involving a university professor's sexual harassment of a student. The ruling stated that when adjudicating a sexual violence case, the court must be careful not to lose gender sensitivity in order to understand issues of gender discrimination in the context in which this incident occurred and to promote gender equality. This became known as a defining precedent for gender-sensitive rulings. One of the Stepping Stone rulings in 2024 was also notable. Even though the victim had gone to a motel after meeting the perpetrator at a karaoke bar, the court still recognized the incident as rape. These meaningful rulings are certainly encouraging. However, as I also mentioned in the presentation, what is urgently needed is fundamental legislative reform. Those are the questions for Mi-kyung Lee. And moving on to the questions that were proposed to Bo-Hwa Kim. The first question was asked by PR Historian. You mentioned at the beginning of the paper that there has been a process of institutionalization of the anti-sexual violence movement in South Korea. Could you please elaborate more on how this process of institutionalization happened, what prototype and why it happened? What are the pros and cons of this institutionalization of the anti-sexual violence movement? In South Korea, the Special Act on Sexual Violence was enacted in 1994, and for the past 3 decades, feminist and advocacy organizations have consistently emphasized that the state bears responsibility for both supporting victims and preventing sexual violence. As a result, a range of services
either Koreans in Korea or Japanese in Japan, which is much harder. Does the identification of foreign sexual perpetrators provide been more or less successful or allow different kinds of approaches in probably discourse, probably of the framing more than the actual prosecution. I don't know how that would work. And so this is both in Japan and in Korea. Because both of part of both of what we heard today.
Because Korean speakers need some time to interpret these questions in Korean. Could you please start first? Yes, thank you.
I can answer about maybe Okinawa. 오늘 강간했을 때 굉장히 더 분노하고 그런 건 있지만 실제로 소파 협약이라든지 이런 것 때문에 한국 내에서 수사 재판하지 않고 미국으로 보내야 되는 그런 문제가 있었습니다. 그리고 물론 이제 다른 외국인들이 한국에 와서 강간을 했을 때는 한국의 법에 의해서 한다고 하지만 그 부분이 여러 통역이라든지 이런 문제들이 좀 있어서 제대로 처벌되지 않는다라고 하는 이런 어려움이 있습니다.
One example that happened in South Korea regarding foreign perpetrators was called the SEAA collaboration, which was when soldiers from the U.S. and South Korea collaborated to execute this court system. So the perpetrators who were from the United States, they returned to the United States to get their court decisions which obviously angered the Koreans because the US soldiers were the ones who committed rape to the Koreans, but the Koreans were frustrated how those soldiers were not being treated in court in Korea, but in another country where they were from, where they would obviously get more advantages rather than being treated in Korea, where they will get harsher treatment.